I am the head of legal programs for Minority Rights Group International, who are hosting this event alongside Human Rights Watch. 10 years ago this month, the European Court of Human Rights found in favour of a case taken by Sejdic Finci, a Bosnian Jew, and Sejdic, an ethnic Roma, against the Bosnian government. The case argued that the country's constitution was discriminatory alongside its election law and preventing them from entering elections for the presidency of Bosnia and for the upper parliamentary body. The constitution and electoral law state that only members of the constituent peoples are eligible to stand for these bodies. Constituent peoples are defined as the following ethnicities: Bosniak, Croat, and Serb. Anyone else is referred to as another. Others include ethnic minority groups who have been resident in Bosnia for centuries, and some of the more vulnerable members of the population. Although the Bosnian government agreed to implement the findings of the European Court, progress was limited. And in 2014, a further judgment was found by the European Court in the case of Azra Zornic, who is with us today. Again, in this case, Azra was denied eligibility to stand for these bodies, the presidency of Bosnia and standing for the upper parliamentary body. In this case, Azra did not wish to identify with a particular ethnic group. She wished to be represented as a citizen of Bosnia alone. Once more, the government of Bosnia agreed to take measures to implement this finding. In 2015, the government created an action plan for the implementation, and one of its objectives was to initiate a task force to oversee the implementation. As of 2019, again, progress on this is limited and the task force has not been created. Minority Rights Group International is an international human rights NGO working in the field of protection of ethnic, linguistic and religious minorities. We have been active in Bosnia since 1999, working closely in partnership with non-constituent minorities in the country. It was Minority Rights Group which represented Mr. Finci in the case before the European Court of Human Rights. And what I would like to highlight is that this issue is not just about whether a person can stand for the presidency, but that it creates a series of serious consequences for the integration of non-constituent minorities into the country, which go beyond these specific elected bodies. Okay, so before we turn to our panelists, I would just like to highlight three key issues which stem from the issue of non-implementation of this ruling, which can frame our discussion today. Firstly, the continuing non-compliance is a refusal by the Bosnian authorities to ensure fundamental and universal human rights are protected in Bosnia. It enshrines discrimination and segregation in the constitution and establishes a precedent for discriminatory practice through different levels of public bodies in Bosnia. Secondly, and I'll use the example of the proposed task force, at present there is no prescribed method for participation of non-constituent minorities within the task force and the implementation of the action plan. And what this does is it highlights a broader issue of a lack of effective mechanisms for effective participation of minorities in public life in Bosnia. This means that minorities who may be among the most vulnerable populations in Bosnia are not able to influence the key decisions which mostly affect their lives. And thirdly, working closely with minority communities in Bosnia, MRG mapped more than 22 cases where this kind of method of segregation between constituents and non-constituent peoples was replicated at local and regional authority level. In theory, decentralized decision-making should be the strongest method for ensuring effective participation of minorities. However, what we are seeing is real-life examples where the inability to represent themselves effectively in decision-making has serious consequences for the situation of their communities and protection of their human rights. Some brief examples I will give, which we mapped in studying the impacts of these kind of methods of participation at local level. We found a case of an elderly returning settlement with no healthcare centre or remote healthcare access provided for them. There was a case of a community which had a very low level of literacy and attendance at schooling, and then in decision making about the allocation of a new school building, they were situated 12 kilometres from the new site with no provision of a school bus for children to access it. One case included the building of a new housing settlement, which included 130 houses, none of which was allocated to a non-constituent minority. So the consequences of this have a very real impact, and this is often not visible to broader community. We're talking about small, often marginalized settlements, and this itself reflects the invisibility, often, of non-constituent minorities in the political process in Bosnia. Of course, 10 years on from the Sejdic Finci case, the finding of the European Court, that is symbolic in itself, but perhaps what is more important, and the reason we want to again try to foreground this issue now, is that with a new government in place, it really is a critical opportunity to try to make some progress on this issue. Clive Baldwin. So Clive Baldwin was working with Minority Rights Group when the Sejdic Finci case was first raised and was the lawyer representing Mr. Finci. He's continued to follow the case very closely and advocating for its implementation on behalf of Human Rights Watch. Clive will talk a little bit about the origins of the case, its legal implications both in terms of Bosnia, but also to bear in mind that this case has an important precedent which goes beyond Bosnia itself.
It's wonderful as always to be back in Sarajevo and in Bosnia and Herzegovina, a place I've been to many times in the last 20 years. And to see a younger version of myself from 10 years ago on the video just now. There's two people missing today. One is Sejdic Finci, who wanted to be here, but unfortunately I think his flight has been delayed, as many are these days. Claire's been a key part of this. The other, sadly, was Sherry Rosenberg, a lawyer who you just saw in the video, who was key to presenting the case and developing how our case was argued, and sadly died a few years ago. But memories of this would just take me back just to say how and when the case began. It began on discussions many of us were having about equality laws around Europe, the new powerful equality provision of the European Convention of Human Rights. And in a meeting someone once asked, doesn't the law in Bosnia and Herzegovina on elections violate equality because some people are classified as other? And someone said yes, and then someone said, I think there are people challenging it in Bosnia, and one of those was Sejdic Finci. So what happens, just very briefly with the case, is a state is taken to court in Strasbourg at the European Court of Human Rights. So we, on behalf of Sejdic Finci with Minority Rights Group, and at the same time Mr. Sejdic, brought their case to say, was the constitution, or the fact that as a Jew and as a Roma, they could not stand for the presidency unless they lied about their ethnicity and declared themselves as something they were not, or for the House of Peoples, was discriminatory. It was unjustifiable difference in treatment because of their religion, because of their ethnicity, and because of their national background. And the key issues which we hear many times over the years, and I hear again in discussions this week, is the arguments the Bosnian government has used was, well, this is a special situation. It was a constitution set up after the war, and is one that can't be changed without bringing the risk of violence, or that it will be too complex to change. The ruling itself by the European Court was very simple but historic. It was simple because the ruling just says denying, well, in this case Mr. Finci and Mr. Sejdic, the ability to stand for the highest offices of the country, the presidency and the House of Peoples, because of their ethnicity, race, religion, is unacceptable discrimination. It's a violation of the European Convention on Human Rights. Whatever the justification, whether acknowledging that this was a constitution drawn up after a civil war. But there's many different ways to have forms of representation, even power sharing, without discriminating in this way. Also, the ruling is historic. It's not just historic for Bosnia, it's historic at the European Court of Human Rights. it was the first time the European Court of Human Rights had found a constitution to violate human rights, because, of course, it's discrimination, calling of some people, citizens as others, is in the Constitution. It was the first ruling on this new, powerful part of the European Convention banning all forms of discrimination. So you could say it's a historic case for Europe, and perhaps the world, as well as Bosnia. So, what makes me sad, though, is that 10 years later, we still have to have a meeting about why the ruling has not been implemented. Not just because it's one ruling, but it's a symptom of many. It is also to stress that the European Court of Human Rights in Strasbourg is one of the most powerful human rights courts in the world. It's one whose rulings get states comply with from some of the most powerful on some of the most difficult issues. So when it made the ruling 10 years ago this month, most people seem to expect that eventually, although there's some complications, the Bosnian government, the Bosnian Assembly, would comply with it. In the end, it said it's for the Bosnia, the state, because its assembly can change the constitution to comply with this ruling and remove the discrimination. So compliance, in some ways, I mean, of course, the politics are difficult, but the actual technical or human rights side to it is simple. It's just change the system, change the constitution and election system in one of many ways, but which no longer means people are prevented from standing from highest office because they happen to be classified as other or forced to declare themselves as something which they are not. Just two other points. First is, because Sejdic Finci couldn't make it, is to say that, as we were arguing in the case 10 years ago and elsewhere, this is a unique situation. No other constitution that we could find in the world classifies some of its citizens as others. Here it's affecting Jews, Rome and many others, including those of different backgrounds, those who do not wish to declare themselves. From the Jewish side, there's no other entrenched discrimination like this in Europe, and the same for other minorities. And Sejdic Finci would say today that it affects, as has already been said, about how minorities can participate in the discussion about return of Jewish property, which is ongoing, is made much more difficult because the Jewish community is not seen as being at the same level. And finally, so it's just looking forward and to say, what is the solution? There is a solution, and it's always been, in some ways, very straightforward. But there's a responsibility, and the responsibility is with the Bosnian Assembly, with Bosnian politicians, first and foremost, because they have the legal power. But there's a responsibility with the US and with the EU and with European states, because the Constitution was, as we know, written and to a large degree and imposed by Americans and Europeans. So it is for US and Europe to help find a solution to this. And the solution remains that after 10 years after the European Court said this was unacceptable form of discrimination, and with the 25th anniversary of the Dayton settlement coming up, and it's time for this to change. So no one should be another in their own country, no one should be treated as another, and no one should have second-class status, as particularly enshrined in the Constitution. So for the European future of Bosnia, it's vital this gets changed and gets changed in the coming year. Thank you.
Okay, thank you, Clive. And a very important aspect which has been mentioned is that it's not just the case that you're denied the possibility to run for certain elected bodies if you belong not to these three constituent ethnicities. If you choose to identify perhaps with the most universal form of identity in the country, simply as a Bosnian citizen, you are also denied this right. And it was on this basis that our next speaker, Azra Zornic, decided to challenge the constitution of Bosnia. And it's important to remember we're talking about two cases here, Sejdic Finci and the Zornic case. So I will give the floor now to Azra, who will talk about her own experience in this, both from a personal perspective and why she considers this important to the country as a whole.
Moji prethodnici su vam govorili o sa historijskog i pravnog aspekta o ova dva predmeta. Ja ću vam se obratiti s aspekta građanke.
Let me now speak about this as a citizen of Bosnia and Herzegovina who does not want to be forced into declaring herself as Bosniak, Serb or Croat, and only because of that, because of our refusal to declare ourselves as members of one of the three constituent peoples, we are denied the basic rights. We simply are forced into a group generally defined as other. As already explained, there is no other similar case anywhere in the world. If you just look around you, there's nowhere on this planet a nation, a people, or a group called other. It is very painful for somebody who was born and raised here, whose family background is from this city, somebody who is from here and of this place in every way imaginable, to be forced to be other on this basis, just not wanting to be one of the three constituent peoples. Automatically, for anyone who is in the category of other, we are treated as second-rate citizens. And let me be clear, this is not just about the election right. If you're filling out a simple job application, you will always be asked about your ethnicity. And if you do not declare your ethnicity as Bosniak, Serb or Croat, you automatically become other. When you are other, your job possibilities, your employment possibilities are significantly reduced. Let me just give you another simple example. The Constitutional Court of Bosnia and Herzegovina draws its competence from the Constitution and is there to protect the constitutional rights of all its citizens. On that basis, if you are not from one of the constituent peoples, you cannot be a member, an elected member of this highest judicial body in the country. Isn't that discrimination? So it's really not just about one right, it's about being discriminated in all walks of life, in all spheres, on all the levels of governance, in the simplest everyday things. You suffer discrimination because you are categorized as other. So what is it in the Constitution that is in fact so discriminating? It is the phrase constituent peoples. The reason why I initiated proceedings before the European Court of Human Rights back in 2005 was exactly that, to hopefully reach a stage when we will have a civic constitution, and we will have a constitution that will guarantee to all its citizens equal rights, irrespective of their religious, national, political, or any other characteristic or background, that we are all treated equally by the Constitution and before the law. That solution is really not that difficult to reach. That solution would also ensure the enforcement of all other judgments that basically relate to the same thing, ensuring that all the citizens in this country are treated equally. There is the Šlaku case, there is the Pilav case, there is the Puderić case, which is still pending, but a judgment is expected fairly soon. All that is required is a change of this part of the Constitution, where it says that Bosnia and Herzegovina shall be a state comprising constituent peoples, i.e. Bosniaks, Serbs and Croats, plus citizens and others. We just want Bosnia and Herzegovina to be a state of its citizens who all have equal rights, equally enjoyed across the territory of Bosnia and Herzegovina. This is again not just related to the election right. This is also, for example, the right to language, so there's no division into Bosniak, Serb or Croat language rights, that there is a Bosnian Herzegovinian language equally accessible and with equal rights for all.
Bosansko-hercegovački.
Okay, thank you, Azra. So in discussing these two important cases and the impact of the Bosnian Constitution in terms of denying effective participation for a number of its own citizens, we have to recognise that this operates in a broader political context, series of challenges, and need for reforms which will lead to greater protection and empowerment of Bosnia's citizens. Within this, as well as political actors, civil society plays a very important role. In particular, in the case of minorities, when they are denied effective means for political participation, civil society takes the role of the main means of representation and participation in society. Within this context, I'd like to give the floor to our next speaker, Vildana Jekman, who represents the Cure Foundation.
When speaking about constitutional reform, those who initiated the topic were in fact women. Women are the majority of the population of this country. 51% of the population of Bosnia and Herzegovina are women. I'm also the public relations person of the initiative Women for Constitutional Changes. This initiative was launched in 2013-14 as an assembly of women's organizations advocating for constitutional reform. The constitution has no gender aspect whatsoever. The idea was to include the gender aspect into the constitution, but we were quick to realize that most of the problems that are troubling women as a part of the population in this country are in fact shared by men. So we expanded our work to focus on 5 priorities that we are currently working on. So we decided to advocate for 5 different priorities as we saw them. One is introducing gender-sensitive language guaranteed through the Constitution and by the Constitution, affirmative measure to ensure gender equality, universal health, social and family protection, better legal protection, better court protection, and ensuring equal rights to all without discrimination as provided for by the Constitution. As it turned out, one of the biggest problems was this third priority, universal rights, i.e. equal rights to health, family and social protection. As it turns out, it took us 7 years to, for example, ensure, and 7 years of hard work and struggle to ensure that there is equal treatment of women who had infertility issues depending on which entity they lived. There are differences in maternity care, there are provisions for maternity care, there are differences in laws providing support for infertility treatment or medically assisted pregnancies. There was a law in Republika Srpska, there was no law in the Federation. So it basically took us 7 years to ensure that all the women who have had issues with infertility were treated equally, irrespective of which part of the country they lived in. There is still the remaining issue of maternity provisions. The Constitution defines your position even in this aspect depending on where you live and also depending on your ethnic background. So not only insisting on ensuring equal rights, what we want to work on is to explain to the citizens that the Constitution is not alien to them. Seen by the people, the Constitution remains something completely out of reach of an ordinary citizen, but it also remains a very powerful tool in the hands of politicians when they want to ensure the status quo by all means that ensures also their unchanged positions. We want to educate, and we continue to work on educating citizens on the importance of participating in constitutional changes, because currently they have no such mechanism to participate in what should be part of their basic rights, but also to educate them on the importance of knowing their constitution and on the importance of feeling their constitution close enough to want to participate in their changing. The Gender Equality Committee did support this gender initiative with gender-based priorities back in 2014, and the Constitutional Committee of the House of Representatives in fact finally agreed to put the gender priorities, as they were called, on their agenda. They agreed to discuss them. Let's be clear, in order to reach the parliamentary procedure, there has to be a green light from the Constitutional Committee, the Select Committee of the Parliament, in order to prepare such a proposal, because there is no other way for changes and amendments to the law to be submitted for parliamentary procedure. The committee hasn't met in quite a while. It continues not to meet. It's not discussing any priorities. This is largely due to a blockage by certain political parties, but the committee, this way or another, is simply not doing its job. We as citizens, and that's one of our priorities, have no direct democracy. Direct democracy does not exist, meaning that we have no tools or mechanisms available to us to become, as citizens, initiators of any such change. We have to wait for various bodies and authorized proponents to do that for us. What we want to ensure, that is why we are active in various campaigns and various advocacy activities, is we want to ensure that the Constitution recognizes me as a woman, me as a citizen, me as anybody in this country, as Mrs. Zornic pointed out, all of us individually as citizens of this country, irrespective of our gender, of our ethnicity, nationality, or any other identification we may opt for, to make sure that we enjoy equal rights across the territory of this country, to be able to receive medical treatment irrespective of where we are living or what ethnicity or anything else we may be anywhere in this country. This is linked to the universal health, family and social protection, which is also one of our priorities. So we just want to ensure that the fundamental civic rights and the fundamental human rights are ensured through the Constitution as the highest legal document of any country. Mrs. Zornic has been not only a collaborator, but I would describe her as a friend as part of this struggle that this initiative of Women for Constitutional Changes has been working on, along with Mr. Sejdic, Mr. Finci, Mr. Pudaric and all other applicants. We will all team up in order to draft and send an open letter to various addresses where influence can be generated to perhaps intensify the pressure to get the process going again, because constitutional reforms are something that cannot and should not be avoided, but it's a process that has been at a standstill that needs to be relaunched. Let me also inform you that we have a blog which is in English and in Bosnian, Serbian and Croatian, and you can not only keep up with our activities, but also by the end of the month we will have published an interview with Indira Bajramovic, who is a Roma woman, who will talk about what the issues that she confronts living as a Roma woman under the constitutional arrangements as they stand at the moment in Bosnia and Herzegovina. Because the idea is that you really cannot speak on somebody's behalf without at least asking what they think and how they feel about it. We want to make sure that all the citizens, including women, are in fact an integral part of the process of changing the law and changing the Constitution as the highest legal document in this country. As a young lawyer, I joined this initiative quite a few years ago, involved in many processes, including drafting changes and amendments to the Constitution of the Federation, which is still pending, but one starts identifying with problems that one may not feel in one's life personally. But women and all other groups or groups in society need a tool, a mechanism that will ensure their full participation in the reforms, because we cannot accept that reforms may be conducted without all those whose lives are directly affected by those provisions are not included in the process. We want to make sure that absolutely everyone is in fact equally involved in the Constitution, because it touches upon everybody's life. I thank you for your attention. I will of course remain available to answer any questions you may have.
Zakon. Ja bih vam se zahvalila, ovdje bi stala i svakako ako bude nekih pitanja tu sam da dam odgovore sa kojima ja raspolažem.